Dave. Okay. Okay, so now we're letting the people in the waiting room in.
Jan, don't add extra talk. Okay, good evening, everyone. Welcome to Night with the Experts. This is a monthly program by Nuclear Energy Information Service in Chicago, where we bring experts to you and you have an opportunity to talk with them, ask questions, have dialogue amongst each other. For the first time, though, in the 2 years we've been doing this, we are having some unusual technical difficulties where for some reason Zoom doesn't want to let our guest in. So we're kind of doing this by hybrid tonight. We're going to have our guest, Terry Lodge, attorney from Ohio, speak on his telephone, and my colleague and board member, Jan Budart, will have his phone near a microphone. So you'll be able to hear him. There's a possibility he might not be able to hear you for a while. So we'll go ahead and do the presentation that way. And then, as some of you who are old timers here know, when Terry's finished, we'll turn the meeting over to Jan Budart, who will moderate the question and answer and dialogue phase of the session. So again, apologies for a rather unusual circumstance we've never encountered before. You won't be able to see Terry's terrific profile, but you will be able to hear his very lawyerly and scholarly voice. So Terry, I want to thank you for joining us tonight. Sorry about the inconvenience here. So I'm just going to get right into it and turn it over to you. I'll let you introduce yourself, and we will begin the Night with the Experts. Thank you. Go ahead, Terry.
Thank you. There's going to be a couple of technical things we're going to have to do differently because of this arrangement. Number one, I've gotten dropped on Jan's phone line a couple of times. The line seems to just go dead. So periodically, if I feel like I've been disconnected, please put up with the bother of my saying, "Can you still hear me?" Because if you don't, then I'll have to redial Jan's phone. Secondly, are you putting up the PDF that I had sent to Jan? Either way is fine, but are you?
Yes, I'm trying to share my screen right now. Let's see. Well, now my screen is not sharing like it. We checked this out before.
All right, tell you what, I will try and bring it up. Jan, just let Terry continue.
Greetings by party line from Northwest Ohio. I'm a long-time practitioner in the Toledo area. I have been practicing law for about 44 years. I've been doing anti-nuclear work since actually being in law school in the late 70s. And I appreciate the opportunity to talk about this weird and exciting time that we find ourselves in, fighting on multiple fronts as the nuclear industry and the nuclear weapons complex emerge more and more clearly as the driver of most of the decision making. As you know, the topic of my talk is generally about making lemons out of lemonade, because the ultra uber right, perhaps the most conservative Court of Appeals, federal Court of Appeals in the country, the Fifth Circuit, headquartered in New Orleans, has rendered a decision on August 25th that actually destroys the NRC, the Nuclear Regulatory Commission's reasoning and issuance of a license for the interim storage partners, also known as waste control specialists, Consolidated Interim Storage Facility in extreme western Texas. CISF is a mouthful. I prefer to simply refer to the ISP WCS dump. So that's what I will mean every day that. To background you on this interesting August 27th, we have to talk about the West Virginia versus Environmental Protection Agency case, a Supreme Court decision on June 30th, 2022. In other words, about 14 months or so ago. The West Virginia decision was met by environmentalists everywhere with a great deal of disgust, disconsolation, great concern, because it critically undermines and is, I think, the beginning of the end of the so-called Chevron doctrine, which is a 1984 Supreme Court case, or I think the Court of Appeals case, that established that agencies do have some wiggle room and leeway when it comes to interpreting the statutes that they're charged with administering or enforcing by way of regulation. The West Virginia versus EPA case, in particular, the facts were that in 2015, the EPA had proposed a clean power plan that was going to ultimately require over 3 years 3 things: efficiency, heat rate improvements for coal plants so they burn coal more efficiently with less pollution, a gradual shift by 2030 where some coal-fired electricity generation would be phased out. Ultimately, there would be about a 27 to 28% of the overall grid would be coal-fired, down from about 38%. And then a continuing shift to natural gas, and even past natural gas, to expand wind and solar for electricity production. The Supreme Court in 2016 put a hold on that. They suspended the plan while litigation took place. President Trump became president, and in 2019, his EPA scrapped the Clean Power Plan, claiming it did not, the US EPA didn't have the power to dictate how to mix power generation sources in terms of phasing things in and out over 50 years. There was an ongoing challenge to that cancellation, and the Supreme Court on June 30, 2022 ruled that the Clean Air Act did not authorize the EPA to shift power generation mix as had been proposed. The Supreme Court invoked a doctrine that they had almost never mentioned before, called the Major Questions Doctrine, where the court, in effect, analyzes by asking if Congress meant to authorize a huge new policy change. And that the Supreme Court said there has to be clear congressional authorization. The US EPA was relying on Section 111 of the Clean Air Act, which was passed in 1970, but that was more authority that EPA as allowing the agency to adopt this very sweeping regulatory policy. The Supreme Court said the EPA couldn't do that because Congress itself had conspicuously, of course, in 1970, declined to enact a permission, if you will, to build into the statute permission for the US EPA to phase out power sources and phase in other power sources. So as I say, the Chevron doctrine, which still exists and still applies and probably is going to be left in place and maybe not explicitly overturned. Chevron doctrine still says, as I stated earlier, that agencies can have some wiggle room to try to explain what they believe Congress intended in order to be in a situation where every change, no matter how minor, in a regulatory policy or an administrative activity being undertaken by an agency. So everything isn't up for dictation to the courts. So the implications of beyond this, I simply understand why the environmental legislative side, the public side of the environmental community is very disturbed by it. However, I read the on 230. We're mired in litigation at the time involving the ISP dump, and I think, as I sat there, I wondered what was in the minds of the likes of Clarence Thomas, Alito, and Roberts when Roberts wrote that decision. Because I think that possibly in their naivete, their ignorance of environmental law requirements, I think that they figured this is a good way to kind of own the liberals. This is we're going to crimp the US EPA, which is sort of a favorite agency of environmentalists and is controversial, but nonetheless seems sometimes to actually move in the right direction in terms of public interest and the environment. And I think that there's a great deal of naivete about understanding that what the West Virginia decision means and what it created is a two-edged sword. Because what I was thinking in June of 2022 was DOE and the NRC are surpassed possibly only by the Pentagon in terms of overt law breaking, live with it, get over it kinds of authoritative and authoritarian missives and messages. And soon thereafter, a number of us, we have a regular meeting of anti-nuclear attorneys that were involved in the Holtec and ISP waste dump. We had a phone conference about it and read the decision and started talking pretty seriously about invoking it in some way. And our allies, our strange bedfellow allies, the Baskin oil interests in Texas, raised it in the Fifth Circuit. And they actually joined in a challenge to the ISP licenses that issued by the NRC. And the state of Texas also raised it. And we're talking, about that state of Texas, that attorney general. So if you go to the second slide, I talk about the fact that the motives of the Supreme Court are not so mysterious. I've already talked about that. It is reality that the US EPA is probably not out of control. It tends in, and in some respects, corporate dominated in its rulemaking and regulation, regulatory policy. But even more so, as I indicated, the NRC is absolutely owned and is the textbook model of the failure of regulation federal level. And I give some examples of where if the doctrine of if the major questions doctrine and the West Virginia case had existed during the waste confidence rule battling a decade or so ago, it's kind of interesting to me whether it even would have been allowed to be considered. Also, more recently, about 4 or 5 years ago, the NRC proposed to create an entirely new class of radioactive waste called very low-level waste, which was poorly designed. And what the NRC proposed to do effectively and really would have allowed literally hundreds or even thousands of ad hoc radioactive waste dumps to be developed anywhere, so long as they met local sanitary landfill requirements. The NRC intended to create an exemption which would allow these kinds of waste dumps to be created and completely unregulated by the Atomic Energy Act. The Atomic Energy Act is the main, what they call organic statute for the NRC and DOE. Anyway, a lot of it, I mean, hundreds of organizations, individuals publicly commented on proposed rulemaking to deregulate, and it was shouted down. But a very clear example, something where the agency is making stuff up out of full cloth and saying, oh, we have general authority under the Atomic Energy Act to do this, so we're going to roll ahead. They abandoned it but only after, among other entities, ISP itself, an applicant for a license to run a nuclear waste dump objected also. Nuclear fuel, spent fuel reprocessing is undergoing reconsideration by the NRC, and many of us are concerned that there will either be a rulemaking or something worse that may have been headed off now by the West Virginia District, that effectively there will be some sort of license pattern created again out of whole cloth that allows, supposedly under the Atomic Energy Act, empowers the NRC to simply create regulations as needed over reprocessing for 30 days. And then the subject actually of the Fifth Circuit decision, the Nuclear Waste Policy Act, was central in the Fifth Circuit decision ruling. The switch, please go down to the next slide, which is titled Nuclear Waste Policy Act. As you can see, there are three major elements of the Nuclear Waste Policy Act passed more than 40 years ago that the NRC has been continuously circumventing. Since 2018, a number of organizations and half dozen or more lawyers, including you, have been involved in representing various intervening organizations against both Holtec and ISP spent fuel dumps. Beyond Nuclear has led the charge, and Sierra Club and also PAC objected to the legality of both the Holtec and ISP proposals because they violate the Nuclear Waste Policy Act. The argument is that Congress has said that the Nuclear Waste Policy Act basically governs, it was the law that said once and for all there's going to be a repository, and that you can't have interim storage dumps until that federal repository is completed and open and operating. The idea in 1982 was that Congress created sort of a pressure relief valve, figuring that it may take some years to really open and operate a deep geological dump, and that to take the pressure off, there could be these temporary holding sites. The intent seems to be that they really were expected to be temporary, a few years, that they holding waste station, if you will. What has happened, and the ISP and Holtec proposals both talk about being private facilities, which would of course be enormously profitable, but both of their proposals contain wording in their application that they want the Department of Energy, the federal government, the taxpayers, in other words, take over all of the liability, all of the monetary responsibility for transporting, paying for storage at the interim site, and then shipping it on to the permanent deposit. That ain't the way the 1982 Act is set up, and these are three key provisions that essentially are that happen. So going on to the next slide, we're now going to talk about the Fifth Circuit decision. I want to say that the Fifth Circuit, as I indicated at the outset, is generally regarded as that there are 12 federal court appeals. This one draws almost all of the judges from Texas, and there are only a couple from elsewhere, like Louisiana. And it's an extremely conservative court. Recently, this summer, decision involving abortion and Stone and other topics have emanated from the Fifth Circuit. And James Ho, who's the judge, who's the nominal author, if you will, the three-judge decision, is one of the super, ultra right-wing judges. He's a Trump appointee. He was a law clerk for Clarence Thomas, and I think that I understand it fairly close to Donald, so he is utterly connected and inside right politics. Anyway, and I want to also just point out that there's probably very few, if any, other district decisions that I would really embrace or endorse other than this. But this is the way law works, and this is the way it works. And when you are intervenors on litigating or administering budgets with two resources that don't have platoons of paralegals and junior associates, do your research writing and hearing, you use whatever weaponry is presented.
Terry, this is Dave Kraft. Could you hold on just 1 second? I think we're going to try and get a better phone connection set up for you. So hold on right there for a moment. I have a thought here. 1 moment. Okay, you're ready to go.
All right. I'm assuming you can hear me.
I can. Mm-hmm.
So I was talking about James Ho, who's the, I don't know if he's the chief judge, but he was the principal judge who wrote the opinion, the three-judge ruling, 26-page opinion that was issued in August of this year. Mainly, the Fifth Circuit, there were standing issues. There were some legal kind of foundational things, rulings that were also made, but the main determination that was rendered by the Fifth Circuit was two-part. First, the Fifth Circuit Defoe decision basically demolishes the NRC's continued reliance over decades, saying something akin to that spaghetti sauce brand a few years ago that advertised that it's in there. Basically, the Atomic Energy Act has been used as referred to as some sort of catch-all authorization to the NRC to do whatever needs to be done by way of regulating special nuclear material, byproduct material, and source material. And I want to add that the Fifth Circuit reasoning is logical. It relies on plain reading and plain understandings, and essentially, as I say, is a very effective counter, which has always been obvious to some of us. The NRC has an awful lot of leeway in kind of making up and sort of stitching things together that may not actually be very good authority for some of the things they do. The Fifth Circuit pointed out that the Atomic Energy Act authorizes the NRC to license the use of various nuclear materials for purposes including research and development, medical therapy, agricultural uses, and utilization and production facilities. The latter category is certainly nuclear power plants and other kinds of research facilities, that sort of stuff. But essentially, there is no mention of waste disposal and storage as actions that the NRC is empowered to license. Ended it out and said that, they overruled that argument. In 2004, there were a pair of decisions. One made in the DC, the District of Columbia Court of Appeals, Bull Creek versus the NRC. That involved a private fuel storage, which was a proposal to create a surface radioactive waste dump in Utah. The same attack that has been raised, in the last year by Faskin in the state of Texas, 2004, was ruled upon differently. The DC Circuit took that liberal construction of the Atomic Energy Act, basically buying the fact that the Atomic Energy Act is interpretable at will by the NRC. And acknowledge that, saying there ain't nothing in there that authorizes the storage or disposal of spent nuclear fuel be licensed. And even points out, in 2004, the DC Circuit made the statement, and it's quoted there on that slide, that one been recognized as a confers authority to license and regulate and dispose, but it's only recognized. It's basically talking about occasionally the NRC has said it has a power and we're not firing behind it. Then the circuit found that the Nuclear Waste Policy Act is a comprehensive scheme for storage and disposal of nuclear waste and spent fuel, and is the only authorization the NRC has to regulate schematic management. That is, in a nutshell, the argument that has been advanced by at least 3 of the intervenors opposed to both ISP and Holtec. It makes sense. It is logical. It's what we were taught in terms of analyzing and constructing logic, court ruling, and law. It's always been very amusing and bemusing that somehow the courts and the agencies find a way to not go with the plain reading. So, as now is that just in the last few days, the NRC has gotten an extension of time. They have indicated that they are going to file the Fifth Circuit en banc reconsideration, which is that all of the 12 or 15 judges on the Fifth Circuit be asked to reconsider the 3-judge ruling that came out on August 25th. For extension time, I think they have to file their legal motion on this about October 24th. That is it's not a mandatory requirement, and it's also probably not calculated. I don't think that the NRC really expects the Fifth Circuit will overrule the 3 judges, but they're doing it, I suspect, to be able to demonstrate to the Supreme Court that they went to the limit in terms of trying to reason with those people. Were not. It's pretty clear that with a sit-in opinion that involves both the DC and Fifth Circuits and also the 10th Circuit, which in 2004 had made a own ruling in the private fuel storage case. A split in circuit opinion in court exists for the most part to bring things together into one legal conclusion and pronouncement. So it's kind of interesting to see where this may be going. That it's probably not going to be argued and addressed, if it is at all, by the court until probably sometime in 2025. And it's going to drag on at least through the end of this year. And it's possible that the circuit might actually overrule the 3 judges and go with the DC, which they probably won't. The fact that the current Texas governor and attorney general had a hand in sponsorship and appointment of an awful lot of the so that's, in a nutshell, the situation. I just would add that, as I mentioned earlier, it is necessary when you're practicing law. I take, in environmental cases, I take the view that they are simply like capital defense cases. They're like death penalty cases. That is, that you use whatever ammunition, weaponry, whatever you want to call it. It doesn't matter what court made the decisions they made to use what you have available. It's not a Democrat Republican. It's not a partisan thing. And I try to guide my environmental practice to the precept that if we do it, it's a day of execution if we win. If they win, it's forever. So the idea is to simply resist as much as possible to a court that is very corporate and opposite direction. Do what you can to stop monstrous, monumental idiocy, such as Consolidated Interim story.
So Terry, that concludes your remarks?
Yes.
All right, I'm going to
That's
stop
what-
sharing. This may be a tad difficult, but we're going to go to the next portion of Night with the Experts, where you will have an opportunity to ask questions or make comments. Hopefully you heard enough today that you'll be able to do that. So I will turn this over to my colleague and board member, Jan Budart, who handles this part of the presentation. Go ahead, Jan. Thank you.
Okay, now most people are familiar with how to ask a question. You go to the bottom of your screen where it says reactions and click on that, and there will be a bar that says raise hand. If you raise your hand, I will be like that, like I just did. It will be very easy for me to find you and call on you. If you don't want to do that and it doesn't work for you, you can go like this, and I'll try, and because I'm keeping a list in a notebook of people who want to ask a question. So I'll try to catch you. Another way that you can do it is to put a question in the chat, and I think Dave will help me. Dave will help me follow the chat, but I'll try to see if you have a question in the chat and call on you that way. I had a question. Is it okay if I start with my question? I put it in the chat. Does the Fifth Circuit consist of 15 judges, and this Texas decision was decided by 3 of them?
Correct.
Okay.
The standard ways it's
Yeah.
the standard ways that cases are dealt with. Yeah.
Okay. But then, and so I'll be quiet now. If somebody would like to ask a question, please go ahead. Carolyn Kroom, go ahead.
I'm sorry to say I didn't hear the argument about if we win, it's temporary. If they win, it's forever. The last few minutes were hard to hear. I realize it might be hard to hear again, but if Mr. Lodge can say it again, or if somebody can summarize who heard it better than me, whatever.
That's a good question, Carolyn.
One of my adages, watchwords, whatever you want to call it, is that if we win, if the environmental side, the people who are trying to protect the Earth win, it's only a stay of execution.
Okay.
I say that because a lot of these projects may be temporarily defeated or derailed, but they come back. Capitalism works over the long haul. Big government works over the long haul. And it is not that uncommon to see ideas being pushed and even turned back or temporarily derailed or politically derailed for a few years, but then they emerge later. Witness the repeated nuclear renaissances that we have been experiencing just in the 21st century. So the saying that I use is, if we win, it's a stay of execution. When they win, whether it's big government or corporate hegemony, when they win, it's forever, because they are destroying the resource. They are impairing the world.
Thank you.
And Craig made the comment, it's asymmetrical warfare.
There's a
Always.
question in chat from Evan Craig. Jan, you want to read that?
Oh, Evan Craig. Oh, sure. So is the concern that if it is decided by the courts that the NRC no longer has waste storage authority, that it also lacks the authority to block a repository by withholding a permit?
No, thing is that the Nuclear Waste Policy Act sets up requirements for how a licensing proceeding will be handled for a deep geological repository. Basically, this decision says follow the Nuclear Waste Policy Act. Now, quit making it up. Quit creating authority that you don't have. It says CISF are not lawful, and it will take an act of Congress to change that. What I think may happen if the U.S. Supreme Court basically says the Fifth Circuit's right, it will add a lot of pressure to Congress. And Congress is as corporately owned. It's the best Congress that money has ever been able to buy. And I'm not greatly optimistic that something noble and progressive and enlightened might happen there. But the idea of consolidated interim storage has troubled me deeply. Among other things, we had a couple of expert witnesses who basically told us that it is very possible, and indeed there are even admissions by Holtec, I believe, that interim is sort of a fluid term, that these two dumps in Texas and New Mexico conceivably could become the permanent resting place in either shallow burial at Holtec or above ground sitting on concrete pads at ISP. In fact, none other than former Texas Governor and Secretary of Energy Ricky Boy said about when Trump's Secretary of Energy, Rick Perry, stated to a congressional subcommittee that it was well known in Texas politics that the ISP dump for spent fuel very likely could turn into the permanent, that's it, that's the place. The problem with either of these two dumps open is that it takes all of the pressure off of Congress and off of the federal government to actually press ahead with a permanent solution. So it is very easy to kick the can down the road, and even easier to call something interim, wink, wink, knowing that we'll all be dead in 100 years, and the waste will still be sitting in the increasingly hot southwestern desert sun.
So I hope everybody heard that. So basically he said that interim storage is permanent storage. Does anyone else have a question they'd like to ask Terry? Michelle, do you? No. Well, I have a question. Can I go ahead with the one I am asking? I don't want to ask it if somebody else has a question. Are you on, Michelle? Oh, that's Terry that keeps coming on. Okay. So here's my question. No, I was mistaking you for Terry's. Can you give us examples of other agencies that have gotten out of control? You explained how the NRC has been functioning. Does the Fifth Circuit think this is also true of the EPA?
I don't know what the Fifth Circuit thinks about the EPA, although I can kind of surmise that it's probably not necessarily a positive view, but a scholar in that particular technical area. Another agency that I think plays incredibly fast and loose with the Atomic Energy Act is the Department of Energy, which is the weapons making side, the weapons making evil twin. In multiple sites around the country, and I would imagine there are people who are advocates and defenders of the downwinder and other victims of some of those sites and processes. But the DOE is extremely problematic and also plays the game of having unlimited authority to do amazing things. In particular, repeated attempts to, among other things, sell on the open global market radioactive metals that are effectively radioactive waste from various and sundry practices and policies and research reactors and other kinds of processes that the DOE oversees, manufacturing weapons and whatnot. As I say, the Pentagon is, of course, constantly hiding behind the cloak of national security, as incidentally does DOE. So yeah, there's a lot of bad actors out there that are very averse to having publicity blaring on their illicit, illegal, outright felonious at times practices, and would be loath. I mean, Congress doesn't want some agencies to come in and want them in a public, possibly embarrassing light to change laws, make some of the dirtier stuff that's being done okay under the law.
Further questions? Well, the DOE is not an agency. The DOE is a cabinet level, I don't want to say agency again, it's a cabinet level thing. And the NRC is not.
I think, Jen, you're confusing things. The NRC is a regulatory agency.
Yeah, and the DOE what?
An administrative agency with some express statutory authority to do things.
Becky, would you please ask your question? You did unmute. Okay, go ahead.
Yes, thank you so much. So I have two questions. Actually, the first one is, so it would seem like their easiest strategy would be just to let it play out in the courts until it gets to the Supreme Court, where it seems like unless something changes, they would have great chance of getting exactly what they wanted. Because it doesn't strike me that the Supreme Court would rule. It seems like the Supreme Court would rule in their favor because it's such a corporate court. Do you think that is true or not true? And when you gave the date 2025, did you mean it would get through the Fifth Circuit, be heard there in 2025, or did you mean it would go on to the Supreme Court in 2025 if Congress doesn't step in?
Okay. Assuming Congress doesn't step in, my prediction is that by the end of this year, or very early in 2024, the circuit will rule on the motion for rehearing en banc, the request for reconsideration. They basically tell or overrule the three-judge panel, agree with the DC Circuit, and ISP's license goes back into effect, and ISP is free to roll on. I would kind of assume that the state of Texas has been, at that point, considered appealing to the Supreme Court. It is made up, of course, of a lot of some of the very best courts that money.
I couldn't quite understand that.
Pardon me?
I couldn't quite understand you. Would you repeat just that last part, please?
The Supreme Court is also extremely corporatist in its ideology. And And it's not necessarily clear cut that they would apply the West Virginia versus EPA decision in the way that this circuit did, because the Supreme Court is showing repeatedly that it's fine with doing whatever is pragmatic, whatever is ad hoc, whatever simply deals with the problem at hand. They don't care a whole lot about the effects of legal precedent, knowing that they can reverse course if they need to down the line. So it is possible, and your suggestion is a good one. That maybe even if it gets to the Supreme Court, they still will not say that yes, the West Virginia case applies here. It's a guess, speculation. If they were consistent, they would say, you're right, NRC, the emperor has no clothes. You can't do what you propose to do. You can't have interim storage dumps. But it's not guaranteed that they will rule that way.
My other part of the question is we're hearing a tremendous amount about these small modular reactors. And of course, they're going to have a lot of waste generated that'll be highly radioactive. So will that waste also fall, as far as you know, or do you know, into the same category as this waste from larger nuclear power plants? And
Yes.
it could also be carried out to the desert and set?
Yes. Yeah, well, although I have to add, some of the reactor designs and some of the kind of ancillary plans that developers of small modulars are verbalizing is that they want to reprocess spent fuel. There's a plan. There are a couple of small modular reactors planned to be constructed in southern Ohio, and our state law was changed to accommodate them. And part of the selling point for the state legislature to pass the new law in Ohio was the waste from Davis, Bessie, and Terry, which are our two operating old-style nuclear reactors, will never have to leave Ohio. We can reprocess it here. With reprocessing is, I won't go on at length, but reprocessing is a very dangerous and foolish and expensive and wasteful practice. And the idea is that you would separate out a lot of the isotopes in order to reuse the uranium as nuclear power plant fuel. The problem is you're separating out tritium, plutonium, and well, a lot of other isotopes such as thorium. So the problem is their proliferation, a nuclear weapons spread kind of concern.
Okay, thank you, Becky. And Ace has to leave, and he made a comment in the chat, and he said he would try to read it before he leaves. So Ace, could you go ahead and read your comment? Because it really fits in with what Terry just said.
Yeah, I only caught most of what Terry was saying, but everything I heard sounded pretty darn good. But my comment is that any temporary storage, and my wife and I did go out to New Mexico to talk to the people there and so forth, and we're from California. But any nuclear industry is going to want to reprocess the waste. They want it all in one place just so that they can reprocess it. And having it and the other problem is that if they have a temporary storage location, they're going to see it as a way to keep making more waste. And that's what we really need to stop, is making more waste. But any solution that they see, that when they started having dry casks, it was the same problem. All of a sudden they have a solution and they just keep making more waste. That's not working out too well. Now they want to give it to somebody else and they're just going to keep making more waste. That's my comment. Thank you very much. I wish I could have heard more of the presentation.
Thank you, Ace. That was pretty accurate. I agree.
Okay. Excuse me. I'm sorry, I got distracted here. Okay, anybody else have a comment or a question? I think there was so much difficulty hearing. Pat will, let's see. She wants to know if somebody would type this up. Well, Carolyn has another question too. So Carolyn, you go ahead and ask your question.
Oh, it's related to what Pat put in the chat, that maybe Terry has a similar presentation that he could share with us, so that would be easier to hear, or something written down that would be easier to share, because what I agree with Pat that it was kind of hard off and on to hear, and I desperately want to know his opinion because I live in Texas, and I've been fighting this, and Pat has, and Becky Halpin, and a whole bunch of other people on this in this meeting. I would like to know. I would like to understand it deeply. So I don't know if Mr. Lodge, if you have another similar presentation you could share.
I don't, but I'd be happy to share the 6 pages of summary, the slideshow.
Okay, great. That would be wonderful.
Yeah, we can make that available along with the chat at the end of tonight's presentation. So we'll send that out to the participants list.
Also, I don't know if people are interested in reading the actual decision. As I say, it's 26 pages, and a lot of it deals with some preliminary legal standing and other matters. But we could also circulate that if people want to read it.
There was something that you sent out that showed the number of organizations that you represent when you when you appear in court with these petitions. Petitions is not the right word, but I thought that was interesting because of the number of organizations and the names of the organizations that you represent when you present these arguments to the court.
Yeah, well, what I've been trying to do, we have the Sierra Club, and Wally Taylor is very capably representing them. You've got the Faston group, which has a tremendous law firm. And Beyond Nuclear, of course, is represented by Mindy and Diane Curran, who is, in my estimation, probably the leading anti-nuke attorney in the country. But I've been representing 7 groups in the ISP case that range from Citizens Environmental Coalition up in upstate New York to a couple of groups in Michigan, including, of course, Don't Waste Michigan. The San Luis Obispo Mothers for Peace, the feed organization in Texas, and of course NEIS. The idea was that this is a national decision, and something in excess of 200 million people, 2/3 of the population of the United States, live within 50 miles of a rail line that is highly likely to be a transit line to New Mexico or Texas. In other words, 95% of all the spent fuel will travel by rail or in the Midwest, southern Lake Michigan, and 200 million people live close enough that they could be downwind of a serious spent fuel accident. So what I was trying to do in the intervention that I've been doing is trying to nationalize the issue and make it very clear to the NRC that it's more than just the people in sort of local regional Texas or local regional southeastern New Mexico that stand to be affected. There will be perhaps as many as 80,000 transports of which will come from all over the east of the Mississippi part of the country. There will be thousands of trips also from the West Coast. But this is a huge transportation campaign, and with the literally millions of miles that will be traveled by transport, you're talking about some serious risk of serious accidents.
Well, I don't know if you're still talking, Terry, but you have faded out. So, oh, Pat, you still wanted to ask a question. I thought you had left your hand up. Go ahead, please. Pat Bulla.
Can you hear me now?
We can hear you.
Recently, my husband and I attended a meeting where Dr. Michael Weber spoke, and he was pretty pro-nuclear. And I didn't get a chance to ask questions after he spoke, but I went up to him individually afterwards, and I said, I have concerns, and particularly about transport of all this nuclear waste and coming to Texas and driving through Texas, and all the railroad derailments. And I said, I'm really concerned about the nuclear waste. I don't think that's been resolved. And he said, yeah, it's a serious problem. And then he said that it would need to be reprocessed before the transporting. That is, if I understand what he said that needs to be reprocessed. And I thought, okay, where is it going to be reprocessed? But I didn't get to ask him. Other people came up and interrupted, so I didn't get to ask him that. So my thinking is, all right, if you're going to reprocess it, you got to ship it somewhere to be reprocessed. Where's that going to happen? And what will happen on the road to being reprocessed? And somebody tonight was saying they want to have it reprocessed in Andrews County or in New Mexico. Is that right? Is that what that we think the plan is? That's my question.
Well, there's a couple of reprocess is a very general broad term. The way I was using it, it typically involves chemical separation of radioactive material. And what Dr. Weber may have been referring to is the fact that it would be necessary and dangerous to move the spent fuel from whatever past storage they're in, sitting at nuclear power plants, into a transport, a device made for the transport of hundreds or 1,000 miles or so. And that's a very large, undiscussed, unmentioned, and unacknowledged problem. That it's a dangerous process to load the stuff onto the train, if you will, and that you have to have a transport device that is lead and very, very heavy and cumbersome and is capable of safely containing radioactivity. I don't know how many of you have traveled on Amtrak, but there are bumpy stretches on freight lines, and it's because of the enormous weight. What? I'll stop.
Yeah.
Anyway,
In fact, I just took an Amtrak trip this summer. Did you
Well,
finish, Terry?
no, all I was saying was that it will be necessary at all of the reactor sites, whether they're currently closed or still operating reactors. There will need to be a very expensive technological process simply to move the fuel into transport canisters or transport casks, however it's done. And yes, the idea that I've heard surface around Holtec is that there is serious discussion about building a facility to chemically separate, reprocess, if you will, spent fuel in New Mexico. So it's not going to be simply a shallow burial dump. And in fact, it's interesting. One of the most troubling aspects of both of these plans is what I call return to sender, which is that if along a 1,000-mile route, if the bumpiness, if there's problems with the spent fuel, if there are problems with the transport device and it cracks, if there are problems where the radioactive waste arrives in New Mexico or Texas and there is some leakage, the solution that is proposed by Holtec and waste control specialists is to send it back to the closed reactor site in Maine, where it came from, or Vermont, or Washington. The idea is not to deal with the problem, not to bear the expense and the technological hassle of making it safe and stable again. It's simply return to sender.
Thank you, Terry. Michelle, go ahead, please.
Yeah, I just put in a link to a recent letter authored by very nuclear experts, including 2 former NRC commissioners, Bradford and McFarlane, on warning Justin Trudeau about the risk of reprocessing in Canada. And in the letter, they also do very summary review of the mess that reprocessing was in the United States. And of course, the West Valley plant ran for a handful of years and shut down in 1972 and is still undergoing cleanup as a Superfund site in New York. So I think when people come up with that I had an adage about a little knowledge being really dangerous. Sometimes these scientists in their bubbles just hear something and it sounds great. It's very high tech. We'll do that. Like if you just throw out like a question like, are you aware of the history so far and the billions, hundreds of billions of taxpayer funds that have been spent dealing with the messes after these companies go bankrupt? And what are your thoughts on who should pay? Which is, of course, the real Achilles heel of the entire transportation scheme, putting aside security risks, safety risks during climate change. Money. Who the heck is going to pay for this? Because it involves not only the costs of the packaging and focused transportation, but you really have to revamp our entire transportation infrastructure, rail lines, roads, and so forth, to be able to handle the sheer weight and size of these transport vehicles. So it's a farce, and it's a scheme to be able to keep funneling money to the industry, which is largely, I think, being done for security reasons. And the security issue can be argued. That's a sort of a separate point. But that seems to me to be what's really going on with a lot of this. Anyway.
You want to comment on that, Terry?
I concur with everything she said.
Okay, well, Michael, you go ahead and raise your question.
Hello. Well, just a comment. What's needed is a hot dry cell at every single reactor site, at every ISCC, and at any CIS interim storage. The casks are going to fail, and there's no way to pull them apart and repackage it. In the absence of a hot dry cell, you're going to have a radiological disaster. There needs to be one in each and every. That's step one. Whether you're pro-nuclear, anti-nuclear, you can't move it from where it is until you can change it from the dry cask into a transportable system. It's just tabletop. The stuff's not moving. either kicking the can down the road or onto the consent. They want to bring in the next generation. It's all about the military atom. There's no economic model that makes any sense. That's it.
Would you mind explaining what you put in the chat? You put in 2 documents with no telling. Maybe you could go into those a little bit.
Thank you, Jan. Yes, those are the briefs that got filed in the circuit court, the Sierra Club, and the Beyond Nuclear. Terry, is the Don't Waste Michigan rolled into the Sierra Club? Is that?
Yeah.
Yep. Okay.
Okay, that's why that was. I don't waste. But
Thanks,
it was.
Jan. Thank you, Jan.
What happened to Michigan Safe Energy Futures? I thought that would be one of them.
So they haven't been one.
Yeah.
I don't
Okay.
think they existed until after we filed anyway.
Okay. Now, if there's anybody else that would like to make a comment or put something in the chat, please do it now. And if you have any closing ideas, Terry, you could go ahead and talk to us about them now.
I think that what we have right now is a lull and a very nervous. Let me say that I take a little bit of pleasure in knowing that for a change, that the NRC legal staff had to get smashed in the head and, are getting a little bit of the medicine that they've dished out so easily and casually for so many years. I think that the Fifth Circuit and the plain reading and the commonsensical interpretation are really troubling because it exposes the weakness of NRC's internal policymaking. Although, of course, we will probably not hear much about any changes that flow from this particular decision. I do think that it gives us, at least for the time being, an upper hand in resisting some of the other game playing that the NRC is doing, particularly with respect to the Palisades, the shut down, the permanently closed Palisades nuclear plant in Michigan, which the NRC is very cooperatively working with Holtec, the same Holtec, to come up with what they call a pathway to relicensing, to do something that is utterly unprecedented, to reopen a 53-year-old rust bucket plant that was plagued throughout its operating life with a number of recurring safety problems, and was classified at one time or another by the NRC as the most embrittled nuclear reactor in the entire U.S. fleet. But the NRC is still hanging in there, basically playing this game with Holtec of figuring out how we can unring the bell, undo the termination of the license. And Holtec's suggestion, and the way they phrase it is amazing. It is so galling. They talk about, we just need a one-time exemption from a section of the NRC reg. And the one-time exemption they're asking for is they want an exemption from the Atomic Energy Act in order to turn around and relicense Palisades to operate. We're going to be raising the West Virginia versus EPA problem with that. But I am sure that there will be other new plans and ideas by the NRC that are illegal, or at least are not justifiable under any construction of the Atomic Energy Act. So that's one thing. The other thing is we have time, we have some pause here to work on Congress and to work against, as a number of people I'm sure on this call, work against changes in the Nuclear Waste Policy Act or the AEA that would allow consolidated storage and might more constructively get us to the point of a permanent repository. We have to stop making more damned garbage, nuclear waste, and that has been a long time stipulation by the anti-nuke movement. We have to be able to get the attention of lawmakers and make it clear that it's time for the most enlightened possible policy, which frankly includes the final death of nuclear power. Don't get me started on weapons.
Now, that certainly is what we would be looking for. Okay, I'm just going to, wait a minute. Well, Stephen is asking, could this lack of reliability in storage be used to stop new nukes, including SMNRs? One would hope so. I think that's what you just talked about, Terry.
Yes.
And it really is probably time to close the meeting, but I just had one other question that I wanted to ask you, because I think that the Fifth Circuit was disciplining the NRC because it has gotten out of control and is going against the US Code of Laws in asking for exemptions and doing things. And I'm wondering if you can tell us about any other agency that is that might be subject to the same kind of discipline as becoming out of control as the NRC.
Yeah, pardon the dog barking. The Federal Energy Regulatory Commission has taken a couple of interesting floggings, not at the Fifth Circuit, but a couple of their longstanding and very corporate biased interpretations of their own regs have gotten crushed in recent years. There might be additional US EPA activity that is ruled out of bounds, but FERC, Federal Energy Regulatory Commission, is a big promoter, of course, of gas mega pipelines and other ancillary types of pipelines, both for fuel as well as other stuff to be transported. They're probably going to get theirs. I have been working with some litigators involving lithium and other rare minerals and the mining practices that are allowed by the Department of the Interior. Maybe some new developments in the pushback from the Department of the Interior. You can almost name any agency, and especially those that exist for corporate welfare reasons or to basically provide kind of an insurance policy against liability for corporate profit seeking, and you'll find enormous corruption. Another agency that does come to mind, Jan, is our little friends in what was formerly the USAID. What is the international DFC? I can't remember what it stands for, but the the U.S. subsidizing entity for development of international projects.
It's called the International Development Finance Corporation.
That's it. Yeah, DFC, right.
But well, this probably is not of general interest, but I get their emails all the time, and every time they put out an email, it has nothing to do with nuclear. It's always some wonderful thing that they're doing, and it looks like Terry got lost. No, he's still here, but it always looks like they're doing some wonderful thing in some remote place that is going to save the lives of many people. Their propaganda is just sickening.
Yep.
Anyway, that's not about, I don't know, it could be about nuclear, but they never say. So, Dave, I think we ought to turn this over to you, and maybe we could, wait, Stephanie has something. The ruling on Citizens United in 2010. Stephanie made it, because you can't read the chat either, Terry, but Stephanie says, the ruling on Citizens United in 2010 has certainly influenced Capitol Hill being the best money can buy.
Yeah.
Yeah, that was,
Yeah,
what-
I
what
mean,
did you say?
it gave corporations a voice, and they certainly have had the voice.
mhm. Yeah, that's what you meant.
And-
This.
But what we're looking at is this country was never a democracy, but it is, whatever it was, is failing. We have mission creep by agencies that can't get any serious scrutiny from Congress, or they just figure, as I alluded to earlier, that they don't need to go to Congress. You don't want to have a public dialogue about controversial changes in policy that will only aid profiteers. So the Congress really doesn't work anymore, except at the employ of corporations, and the agencies are often beholden in many, many ways to the industries and businesses that they regulate, and yes, it all became steroidal, as though it weren't before, in 2010.
Have you ever heard of France sending waste to the United States?
That was my
There is
question.
something-
Yeah,
there is-
I forgot. I didn't notice your hand was up, Pat. I was reading.
Mike Keegan could probably tell you more, but yes, there has been discussion as there is some questioning as to the overcapacity reflected particularly in the Holtec proposal. And there have actually been some, I think there was an experimental pseudo transport from Japan or someplace in Europe to see if it would be feasible for nuclear waste to come to the United States from other countries for what I call disposal in the ISP or Holtec dump.
Mm. And then there was Estonia sending its waste to Utah.
Oh yeah,
That took place. I mean, the waste from Estonia did come into the White Mesa Mill.
Wait, Mesa,
So, go ahead, Pat.
what
please
Mesa, what, Mesa, what?
The White Mesa Mill in Utah accepted waste from Estonia.
No, I didn't know that. Woo.
So let's turn this over to Dave, unless there is. Oh my gosh, Becky says she thinks that France is part owner of the Texas site. We should look that.
correct.
Oh, is that correct, Michelle? No.
Yes,
Okay.
Toronto.
Is it Your Honor or
Your Honor, Arano, USA. You know, it's the U.S. Subsidiary of Arano.
ORANO.
Okay, folks, so let's turn it back to Dave and he can close out the meeting.
Thank you, Jan. And Terry, thank you. We are perplexed and embarrassed about what happened with Zoom tonight, but appreciate your perseverance and also the perseverance of the listeners tonight. We did the best we could, and we'll do the best we can to get information out to you. As Terry mentioned, we will be sending out the PowerPoint slides that he presented tonight and some background materials as well, probably this evening at some point. And we'll do the best we can on seeing what we can do about that audio and maybe getting a transcript. I want to mention that our next Night with the Experts will be October 26th, the fourth Thursday of October. It's just before Halloween, so who knows what you'll get? We're not quite sure, but stay tuned, as they say. We do have some ideas in the hopper, and it might be something a little different, but we'll keep you posted on that one. And we'd also like to invite you to a monthly program called Meme the Media, where we attempt to get our language and our memes into the media and confront the nuclear memes as much as possible. The next one will be on the 30th of October, day before Halloween, 7 o'clock Central Time, and you'll get an announcement about that as well. So again, thank you all for coming tonight. Terry, thank you so much for putting this together. Sorry about the problems, and we will be back in touch soon. So everyone, stay well, have a good evening, and we'll see you again soon, we hope.
Thanks for coming, everyone.